Hello everyone and welcome to this video tutorial in which we're going to be looking at a suggested answer to a tort exam question, and this video is about the rule in Rylands and Fletcher. So this is an evaluative essay question, and here's the question that we're going to look at. The rule in Rylands and Fletcher has no place in modern tort law. It is both unfair and wrong to impose strict liability in tort. Discuss. So for this question, you need to do two key things. Firstly, you need to explain all of the rules, all of the cases, all of the principles from the rule in Rylands and Fletcher. And secondly, you need to evaluate the law. So I've got a suggested answer here for you, and as usual, I've colour-coded it. So any rules and principles from the rule in Rylands and Fletcher are in black font, and any evaluation which is answering this analysis question are in red font. And I've also highlighted the cases in yellow to make them stand out a little bit better for you. So an important way of starting any essay question is to look at the topic that you're being asked to explain or discuss, i.e. Rylands and Fletcher here, and start by defining that rule. So you can see in the introduction here, I've said that Rylands and Fletcher is a particular type of nuisance, and it protects an occupier against interference caused by an isolated, i.e. a one-off escape from a neighbour's land. And it's a form of strict liability because our defendant can be liable in the absence of any negligent conduct on their part. And you can see I've gone into some evaluation here where I'm starting to refer back to the question, and I'm saying that the application of strict liability is contentious or controversial in tort because it looks at the harmful result rather than to the kind of conduct. And that's very different from the traditional fault-based system that we're used to in negligence. So I'm referring back to this question that it does seem in a way unfair to impose strict liability in tort. And because of this, a rather restrictive approach has been taken to the tort, and there have been, I should say, attempts to do away with it. So there have been attempts by the judges to try and sort of get around it, but the House of Lords have retained it. So in that short introduction, you can see I've got a definition and I'm referring back to the question. I'm sort of saying that, yep, strict liability is a bit controversial, and that leads me on to the next rule in Rylands. So it's useful to just outline what happened in the case of Rylands and Fletcher. So Fletcher had a reservoir built on his land. The reservoir burst and flooded a neighbouring mine run by Ryland. And this was a House of Lords case. And the House of Lords ruled that the defendants were strictly liable for the escape and that they ought to pay damages to the claimant. And the judge in that case, Blackburn Lord Justice, justified this decision by saying that a person must keep a dangerous thing at his peril. And it seems fair that the defendants ought to be liable for one-off events that are not covered by the tort of nuisance if they've kept something that's potentially dangerous on their land. So again, that red font is referring back to the question. And you'll start to see a pattern in this answer in that it sort of goes black, red, and so on. And that's showing that we've got a nice mixture of rule and evaluation. So whenever you're tackling an essay like this, try and give some facts. And if you can, try to then refer back to whether they're fair or not. So I'm then going on to explain the four rules that have come from Rylands and Fletcher. And there's no liability, first of all, for a thing that naturally accumulates. And we can use the old case of Giles and Walker for that, where seeds from some thistles on the defendant's land blew into the neighbouring land owned by the claimant. Our defendant wasn't liable because he hadn't brought the thistles on his land. So straight away, try and make a comment on that case and evaluate it. So this rule may be unfair on the claimant, where the defendant doesn't do anything dangerous, or sorry, doesn't do anything about dangerous things that are naturally accumulating. And you could say that that seems a bit unfair, because if you know that that's potentially going to cause harm to others, even if it did arrive there naturally, maybe you ought reasonably to do something about it. Secondly, there has to be a non-natural use of the land. And this is where you can talk about the fact that this concept has allowed the courts to adopt a flexible approach. And it's meant that they can adapt the application of what is an ancient rule, really, to changing circumstances. So, in a way, that's an advantage. But there is a problem in identifying what amounts to a non natural use of land. Because if that's going to develop over time, it's then going to be hard to advise your clients on this. So non-natural use has become interpreted by the courts as meaning non-ordinary use. And that further restricts the application of the rule in Rylands. And this has resulted in unpredictability and confusion. And Viscount Simon, in the case of Reed and Lyons, said, quote, "I confess to finding this test of non-natural user difficult to apply." Now, if a judge is finding the rule difficult to apply, that's telling you that the law is problematic here. The cases have developed the rule further, so Rickards and Lothian, Lord Moulton said that it must be, quote, "some special use bringing with it increased danger to others." But a bit of evaluation here, there's been real difficulties in showing non-natural use in a technological age. So Cambridge water, you could talk about the fact that chemicals on industrial premises was described as an almost classic case of non-natural use, even though it was in an industrial area. Surely you would expect chemicals in such an area. The House of Lords have described this non-natural use as meaning extraordinary and unusual. Transco plc further developed it, and they talked about the provision of water supply to a block of flats was a natural use. And Hoffman said that the rule in Rylands and Fletcher is engaged only where the defendant's use is shown to be extraordinary and unusual. The third rule is that the thing must be likely to do mischief if it escapes. And in terms of evaluation, you can say that this has proved to be confusing, because in Hale and Jennings, a roundabout chair on a fairground ride was held to have met this rule when it broke and flew off. It was held that the thing need not be inherently hazardous itself, only likely to be causing damage if it escapes. And Reed and Lyons, the court limited the meaning of escape to being where the dangerous thing moved from the defendant's premises to the claimant's. But there are contrary tests in Hale and in British Celanese and A.H. Hunt. So whenever you've got contrary tests, conflicting rules, that's telling you that the law's unfair, really, isn't it? Because we shouldn't have a conflict. It should be consistent for all parties. The fourth requirement is the damage must not be too remote. Again, you could use Cambridge water here. And this rule further has the effect of limiting the tort, restricting its use, again indicating that we're not really too happy with this rule. We want to limit where it's being used. And another problem in proving the tort is that there are a huge number of defences. And you could start to list some of these, such as consent, act of God, act of a stranger, statutory authority, contributory negligence, and do use, as I have, cases to support the points that you're making there. Notice I haven't explained everything that's happened in all of these cases. They're simply there to support the rule that I've outlined. So the fact that there are a huge number of possible defences, again, illustrates that the problems that we have with the tort and its unpredictability. There are strong arguments that the tort is outdated. There are very few successful claims. Other places, such as Canada and Australia, have all found the rule to be ineffective and outdated. Australia, it's no longer applicable, but has been modified in negligence. So that could be a potential option for us here. You could go on to talk about the fact that there is an overlap with Rylands with the area of private nuisance. And so because of this overlap, the English courts have questioned the relationship between the rule and this other tort. And you can see Lord Gough in Cambridge Water said, quote, "It would lead to a more coherent body of common law principles if the rule in Rylands and Fletcher were to be regarded as essentially an extension of the law of nuisance to isolated escapes." House of Lords in Transco confirmed that the rule should be treated as a subspecies of private nuisance. So another bit of evaluation, referring back to our question, there'll never be a case where a claimant will succeed in Rylands without also succeeding in nuisance. And therefore, it supports an argument that we should just get rid of Rylands. We should move away from it. We can cope with it, with the issues that come from it with private nuisance anyway. And in terms of starting to reach a conclusion, we could say that Rylands has developed away from the liability that it was originally designed to cover. And the style of liability apparently envisaged by Blackburn J in the original case was for a general head of liability for accumulations of hazardous things that did damage. What he was envisaging probably wouldn't include damage by a roundabout chair, like in the case of Hale and Jennings. So I'm making the argument here that it's perhaps gone much further than it should have in any event. It's useful to end by talking about the Law Commission, who've also criticised the rule. And in one of their reports, they said that they thought the Rylands and Fletcher was not too useful, and that any benefits provided by its simplicity and flexibility would be outweighed by difficulties in its application. So you can see there, we've achieved two things. We've explained all of the rules and the key cases in Rylands and Fletcher, and we have explained all of the main reasons why people have said that this particular tort is unfair. And we've made some tentative suggestions about what we could do to reform the area. Perhaps we could abolish it and just rely on private nuisance to solve any problems that would otherwise be covered by this tort. So I hope that video has been useful. Remember, I do have other videos on my channel on Rylands and Fletcher and private nuisance if you want to have a refresher on either of those torts.